November 20th, 1945. Palace of Justice, Nuremberg, Germany. 21 men sit in 2 rows of a prisoner's dock constructed specifically for this moment. Men who months earlier had commanded armies and administered territories and made decisions that determined whether millions of people lived or died. Men who had worn elaborate uniforms covered in medals and had been addressed with titles that communicated absolute authority and who had experienced themselves as historical figures, implementing world historical missions. Now, they wear simple suits provided by their captors, sit behind wooden barriers guarded by military police, wait for proceedings to begin in a courtroom that has been transformed into something unprecedented in human history. A tribunal where victors will judge the defeated not simply for losing a war, but for crimes that transcend warfare itself, for systematic murder implemented through bureaucratic efficiency, for genocide conducted as state policy and documented in their own meticulous records. The courtroom is silent in the way that spaces become silent when the weight of what is about to happen suppresses ordinary human noise and movement. Journalists from across the world fill the gallery. Prosecutors from 4 nations have spent months preparing evidence. The judges enter and everyone stands. This is the moment when humanity attempts something it has never successfully accomplished. Holding individuals accountable for atrocities committed through state power, asserting that there exist crimes so fundamental that they transcend national sovereignty, and that those who commit them cannot hide behind the defense that they were simply following the orders of legitimate authority. The question that hangs unspoken in the air is whether justice can be invented after the crime has been committed, whether victors can judge the defeated without the entire proceeding collapsing into nothing more than revenge dressed in judicial robes. Welcome to Forgotten Minds. Today, we examine the Nuremberg Trials as a collision between law and atrocity, as humanity's first comprehensive attempt to hold leaders accountable for genocide and crimes against humanity, and as a window into the psychology of perpetrators confronted with evidence of their crimes and forced to construct defenses and narratives that might preserve some fragment of their self-concept against the overwhelming documentation of what they had actually done. Hermann Göring sits in the first seat of the front row, positioned by his captors according to the hierarchy of power and responsibility within the Nazi regime. And he immediately begins attempting to reassert the dominance and authority that had defined his role within that regime, treating the proceedings not as a trial where he faces judgment, but as a stage where he can continue to perform the role of the important leader, addressing lesser beings who fail to understand the historical forces they are presuming to judge. He has lost the massive weight that morphine addiction and luxury had added to his frame during the war years, has regained, during imprisonment, a mental clarity that had been absent for more than a decade. And he uses that clarity to construct a defense that acknowledges nothing while appearing to engage seriously with the charges, to mock the proceedings while maintaining the appearance of cooperation, to position himself as the reasonable and intelligent Nazi who can explain to naive prosecutors and judges why their moral framework fails to comprehend the necessities of power and survival. Albert Speer presents an entirely different performance, having calculated that his best chance of survival lies in presenting himself as the cultured technocrat who had been seduced by Hitler's charisma and who had remained ignorant of the regime's worst crimes, because he was focused on architectural plans and production statistics, as someone fundamentally different from the obvious fanatics and criminals who surround him in the dock. His testimony acknowledges collective responsibility while denying personal knowledge of specific atrocities, expresses regret for not having questioned or investigated what was happening, while maintaining that he was simply an architect and administrator, rather than an ideologue or a perpetrator, performs a kind of confession that appears honest while actually obscuring the full extent of his knowledge and his active facilitation of genocide through his management of slave labour and his collaboration with the SS. Joachim von Ribbentrop, the former foreign minister who had negotiated treaties and represented Nazi Germany in diplomatic contexts, collapses entirely under the pressure of the trial, demonstrating none of the composure or intelligence that his position should have required, appearing instead as a broken man who weeps and claims ignorance and shifts blame to others, and presents himself as a victim of circumstances beyond his control. His defense consists primarily of claiming that he was simply implementing Hitler's foreign policy decisions and that he bore no responsibility for how those policies connected to or facilitated the atrocities that follow from them, that he was a diplomat rather than a criminal, and that diplomatic activity cannot be prosecuted as criminal regardless of what purposes it served. The primary defense that emerges across almost all defendants, articulated in different forms and with different degrees of sophistication but fundamentally the same in its psychological mechanism, is the displacement of responsibility upward through the chain of command. They were following orders, they were implementing decisions made by others, they were simply performing their assigned roles within a system where questioning orders was impossible and where individual moral judgment was subordinated to hierarchical authority and organizational loyalty. This defense had a surface plausibility because the Nazi regime had indeed been organized as a strict hierarchy where subordinates were expected to implement the directives of their superiors without question. Yet the prosecution systematically demonstrated through documents and testimony that these men had not been passive implementers, but active architects and enthusiastic participants who had often exceeded their orders and who had taken initiative in solving problems and overcoming obstacles to the implementation of genocide. When confronted with documentary evidence of the Wannsee Conference, where the final solution was planned and coordinated, when shown photographs from concentration camps documenting the industrial scale of murder and the condition of survivors at liberation, when presented with their own orders and correspondence, and reports that demonstrated intimate knowledge of and participation in systematic killing, the defendants respond with various forms of denial and deflection that reveal the psychological mechanisms through which they had maintained their self-concepts during the commission of their crimes. Some claim the documents are forgeries or that their signatures were forged. Some acknowledge the documents, but claim they do not understand their full implications at the time they signed them. Some admit knowledge, but claim they objected internally, or attempted to moderate the policies, or had no choice but to comply. Göring in particular refuses to perform contrition or acknowledge moral wrong, instead defending Nazi policies as legitimate exercises of state power and racial self-defense, arguing that the Allies lack moral standing to judge because they had committed their own atrocities including the bombing of German cities and the use of atomic weapons against Japan, attempting to transform the trial from a prosecution of Nazi crimes into a debate about the moral equivalence of all warfare and all exercises of state power. His performance is sophisticated enough and his intelligence formidable enough that he succeeds in dominating portions of his cross-examination, in frustrating prosecutors, and in providing what other defendants see as vindication of their own choices to remain loyal to Nazi ideology, even in defeat. The prosecution presents evidence with systematic thoroughness designed to make denial impossible, and to demonstrate beyond any conceivable doubt that the Nazi regime had implemented systematic genocide as state policy, and that the men in the dock had been central to planning and implementing that genocide. The Wannsee Conference Protocol, discovered in German archives and authenticated through multiple sources, provides documentary evidence that the extermination of European Jewry had been explicitly discussed and planned by high-ranking officials, including several of the defendants, that the language of evacuation and resettlement used in official documents was understood by all participants to mean systematic murder, that the logistical challenges of transporting and killing millions of people had been approached as administrative problems to be solved through coordination between various government agencies. Photographs and film footage from concentration camps liberated by Allied forces are shown in the courtroom. Images so devastating that several defendants look away or close their eyes or claim to be seeing this evidence for the first time, despite their documented knowledge. And in some cases, direct visits to the camps during the war. Testimony from survivors provides first-hand accounts of conditions in the camps and of the systematic procedures through which people were selected for immediate death or temporary exploitation through forced labour, of the violence and starvation and disease that characterised daily existence, of the gas chambers and crematoria that had been designed and constructed specifically for efficient mass murder, reports from Einsatzgruppen commanders documenting the mass shootings of Jews and others in occupied Soviet territories are entered into evidence, demonstrating that the killing had begun well before the extermination camps became operational, and that it had been conducted openly enough that thousands of German soldiers and administrators had witnessed it or participated in it. These reports use bureaucratic language to describe atrocities, referring to actions and special treatment, and listing victims by category and number in tables that present mass murder as statistical data, revealing with chilling clarity how administrative procedure and euphemistic language had allowed perpetrators to maintain psychological distance from the human reality of what they were doing. On October 1st, 1946, after months of testimony and deliberation, the tribunal announces its verdicts. 12 defendants are sentenced to death by hanging. 3 receive life imprisonment. 4 receive prison sentences ranging from 10 to 20 years. 3 are acquitted. Decisions that provoke controversy and demonstrate that the tribunal was attempting to distinguish degrees of responsibility and to apply genuine legal standards, rather than simply imposing collective punishment on everyone associated with the regime. Hermann Göring is sentenced to death, but manages to obtain cyanide and commits suicide hours before his scheduled execution on October 16, 1946, denying his executioners the satisfaction of killing him, and ensuring that his death would be remembered as an act of defiance rather than as submission to the judgment of his enemies. The remaining condemned men are hanged in the early morning hours, with witnesses reporting that some went to their deaths maintaining Nazi loyalty while others collapsed into incoherent terror, that Joachim von Ribbentrop's final words were "God protect Germany," that Alfred Jodl died silently, that Julius Streicher shouted "Heil Hitler" before the trap door opened. Albert Speer, having successfully performed his role as the repentant technocrat, receives 20 years imprisonment rather than execution, serves his full sentence at Spandau prison, and emerges in 1966 to write memoirs that cement his false narrative of ignorant complicity and that allow him to escape full historical accountability for crimes that he had not merely enabled through passive ignorance, but had actively facilitated through his organizational genius and his willing use of slave labor. The Nuremberg Trials establish precedents in international law that remain foundational to contemporary understanding of crimes against humanity and individual responsibility for atrocities committed through state authority, that superior orders do not eliminate personal moral responsibility for actions that violate fundamental principles of human dignity, that there exist crimes so severe that they transcend national sovereignty and can be prosecuted by international tribunals, that individuals who plan and implement genocide can be held criminally accountable regardless of whether their actions were legal under the laws of their own nations at the time they committed them. Yet the trials also revealed uncomfortable truths about the limitations of justice and accountability when confronting systematic atrocity. Many perpetrators escaped prosecution entirely through death or through successful evasion, including Adolf Eichmann, who would not be captured until 1960, and Martin Bormann, whose fate remains uncertain. The defences presented by the defendants, particularly the claim that they were simply following orders and bore no personal responsibility for implementing policies decided by their superiors, demonstrated how hierarchical authority structures can create conditions where individuals can participate in genocide while maintaining psychological narratives that absolve them of moral responsibility. The trial format itself, while necessary for establishing legal precedent and creating historical record, could not adequately address the psychological mechanisms that had allowed ordinary men to become architects of genocide or provide comprehensive accountability for crimes that involved thousands of perpetrators and millions of victims. This has been Forgotten Minds. The Nuremberg Trials represented humanity's first systematic attempt to hold leaders accountable for crimes against humanity, establishing legal principles that would influence international law for decades, and creating historical documentation that would make denial of Nazi atrocities far more difficult, yet the psychological distance between the courtroom proceedings and the actual atrocities being prosecuted remained vast and unbridgeable, with no verdict or sentence capable of restoring what had been destroyed, or of providing justice proportional to crimes of such magnitude, leaving only the warning that such crimes remain possible whenever societies abandon the safeguards that prevent the concentration of power and the dehumanization of targeted populations, and the precedent that individuals who commit such crimes can be held accountable even when they acted under the authority of sovereign states. Until next time, stay vigilant.